Section 79, presumption as to genuineness of a certified copies. Section 79 to 90 deals with certain presumption as to documents. This section proceeds upon the maxim omnia prasemuntur rite esse acta, means all acts are presumed to be rightly done. In fact, all the following section down to section 90 inclusive are illustrations of and founded upon this principle. But though the courts are directed to draw presumption in favor of official certificates, it is not conclusive presumption, it is rebuttable. It is but a prima facie presumption, and if the certificate etc. be not correct, its correctness may be shown on the same maxim stands. The last clause of this section, it is very old law, that where a person acts in an official capacity, he shall be presumed that he was duly appointed. This section applies to certificates. Certified copies are other documents which are duly certified by an officer of the central government or the state government, or by an officer in the state of Jammu and Kashmir who is authorized by the central government in that behalf to be genuine. The section has also been held to apply a carbon copy of a court order issued in official process, though not a certified as a true copy. In a case of Sitaram versus Ramcharan, AIR 1995, MP 134, it was held that in a suit for permanent injunction, the certified copy of khasra entry made by the patwari showing the defendant as the subtenant could not be presumed to be correct, as no evidence was adduced to prove that entry and the patwari who made the entry was not examined. In a case of Tata Chemicals Limited, Bombay versus Sadhu Singh, AIR 1994, Allahabad 66, it was held that a certified copy of a registered sale deed is admissible in evidence without examining the vendor or a vendee as the witnesses. Under Section 80, presumption as to documents produced as a records of evidence. The presumption to be raised under this section are considerably wider than those under Section 79. They embrace not only genuineness of the document, but that it was duly taken and given under the circumstances recorded in the document. The presumption under this section are not conclusive, they may be rebutted. The section is applicable to a document which purports to be record or memorandum of the evidence given by the witness in a judicial proceeding, or before any authority authorized by the law to take such evidence, and to statement or a confession by an accused person taken in accordance with the law, signed by any judge or magistrate. The section dispenses with the necessity for a formal proof in a case of certain documents taken in accordance with law. If a document has not been taken in accordance with law, this section does not operate to render it admissible. Under Section 81, presumption as to gazettes, newspaper, private acts of a parliament and other documents. The government gazette or a newspaper or a journal are copies of a private act of a parliament printed by the king, printed by the king's printer, are prima facie proof of their genuineness. The second part of this section includes most of the documents which contain matters referred to in a Section 35 and which are declared to be public document by Section 74. Genuineness of the Gazette of Bombay Presidency published in 1879 was presumed so far as the statement recorded showed the historical material on the matter in dispute, namely whether the temple in question, which was of ancient origin was a public trust. It was considered to be an expert evidence under section 45 and also evidence from a public record under section 35. Clause in a government contract providing for arbitration was deleted and a notification to that effect was published in an official gazette. The court said that it attracted the presumption under section 23 subsection 5 of the General Clauses Act of 1897 and section 81 of the Evidence Act. It became binding on the parties in respect of their commercial transaction with the government. Statement contained in the Gazette can be taken into account to discover historical material contained in it. Fact states in it are evidence under section 81. In a case of carriage of goods by sea, the bill of lading is evidence to establish the fact that the goods were actually put on a board by the master of the ship, unless proved otherwise. The content of and the details mentioned in the bill of lading are presumed to be true. The presumption of genuineness attached to this section to a newspaper cannot be treated as a proof of the fact reported therein, and the statement of the fact contained in a newspaper merely hearsay and therefore inadmissible in evidence. The translated copies of the news item cannot be considered by the court as a document in the absence of original newspaper. The newspaper as a whole must be filed before the court. The matter published in newspaper are not admissible in themselves. The presumption of genuineness cannot be treated as a proof of the fact stated in the newspaper report. Such statement of the fact is only hearsay. Section 82. Presumption as to documents admissible in England without proof of seal or a signature. This section enables the court to recognize presumption with regard to certain classes of documents which are recognized in English courts. The court must presume that the seal or a stamp or a signature is genuine and that the person signing the document held at the time when he signed the judicial or official character claims. The document which, without proof of the seal or signature or the official character of the person by whom they purports to have been signed, are admissible in England, will be admissible in courts in India. Section 83. Presumption as to maps, plans made by the authority of the government. Presumption as a accuracy is limited only to a maps or a plans made under the authority of the government. Such maps or plans contain the result of the inquiries made under the competent public authority. In all other cases, proof of accuracy is needed. Where maps are prepared by the private person, no presumption in favor of accuracy can be drawn under this section. This section must be read with section 36, which deal with the statements in a map, chart and plans. These are provable under section 77 and section 79 by the production of certified copies. Maps and surveys made in India for revenue purpose are official documents prepared by competent person and with such publicity and notice to a person interested as to be admissible and valuable evidence of the state of things at the time they are made. They are not conclusive and may not be shown to be wrong, but in the absence of evidence to the contrary, they may be properly, judicially received in evidence as a correct when made. Where the survey number in a dispute was covered by the development plan of the municipal limits, which was prepared in compilation with the statutory provisions, its correctness will be presumed, and mere collection of taxes by panchayat did not disentitle the municipal corporation to levy octroi. Where the site plans and the inventory prepared on behalf of former ruler was not produced in its original state, the Supreme Court did not allow any objection to be raised about the matter in the Supreme Court. The section concludes providing that maps made for any particular cause must be proved to be accurate. This can be done by examining a person who actually prepared them. Any defects or infirmity can be overcome by bringing before the court the maker of the maps, etc., and testifying the accuracy.